everyone. I'm Monica Hakimi, a professor of law at the University of Michigan Law School and a member of the Board of Editors of the American Journal of International Law. This video is part of a series called AJIL Bookmarked. The idea is for members of AJIL's editorial board to highlight or bookmark articles from the journal's back catalog for viewers to read. I've decided to dig into the issues from the 1960s. This period is especially interesting to me because it was one of considerable openness and disruption, when international law's future trajectory was in some sense up for grabs and therefore in doubt. The article that I'll bookmark is by the Indian international lawyer R.P. Anand and was published in 1962. It's entitled, "Role of the New Asian African Countries in the Present International Legal Order." Anand's article demonstrates powerfully two central motifs that appear in articles from this decade. The first is deep dissatisfaction with the then existing international law. In this passage, Anand underscores that the present international law was developed during the last 4 centuries and specially consolidated and systematized during the last part of the 19th and beginning of the present century. Asian and African countries had very little to do with it because they were conquered and colonized. Anand says that these new countries want nothing less than the liquidation of imperialism in its widest meanings, with all its political, military, economic, and psychological implications. They want to change the status quo and are striving to restructure their societies and the international society to reach a more equitable situation. International law, as then constituted, reflected the remnants of colonialism and was, for that reason, deeply inadequate. But consistent with the second motif of this period, Anand also had considerable faith in international law as an instrument for positive change. He saw international law not primarily as a problem for new states, but also, and mostly I would say, as the solution. He at one point underscores that most of these states accept the basic tenets of international law. He takes this to mean that there is not, and I'm quoting, a need for any radical change in international law. He also puts a lot of weight in the International Court of Justice, as in his words, the most promising instrumentality there is for peace. And he presents a vision for international law defined by concessions on both sides, not by threats or unnecessary criticism. This is an affirming vision, one in which international law serves the global common good through reform, adaptation, compromise, and self-restraint. Anand does not in the piece grapple with the tension between these two motifs. He does not explore how states of the global south might change the status quo using legal constructs that reflect and perpetuate it. That tension, I want to suggest, still defines much of the field. Many international lawyers see the enterprise, like Anand seemed to see it, as reifying the power structures of the past. This motif continues to resonate with the themes of an intellectual tradition that goes by the acronym TWAIL, for Third World Approaches to International Law. Although TWAIL scholarship has by now lost some of Anand's faith in the institutions of international law, many other traditions in the discipline have not. In other words, many continue to see international law as at once a product of the power structures of the past and an instrument for overcoming those structures for the common good. Because Anand does not grapple with this tension, he does not try to resolve it. But perhaps we shouldn't expect him to. I want to suggest that the piece is still worth reading today precisely because it preserves this tension. It reminds us that international law both reifies the problems of the past and offers opportunities for positive change. That message seems particularly salient in 2021. Now again, we're in a period of openness and disruption, when international law's future trajectory is unknown and to some extent up for grabs. As I see it, and I don't think I'm alone in this regard, there's a lot about the status quo in which international law is deeply embedded that we should want to change. But there's also quite a bit about the enterprise that we might want to preserve. The difficult questions, which Anand's article tees up but cannot answer for us, are what about international law falls into each of these categories? What should we want to change about international law, and how should we go about changing it? And what should we try to preserve and how? The answers to these questions will not be the same now as they were in the 1960s, but the questions are very much still with us. I hope you enjoyed this brief look back through the AJIL archive, and I hope it inspires your own discoveries from the journal's pages. Happy reading.